Good afternoon. Thank you for joining me. If 2020 was known as the Zoom year election amid a pandemic, 2024 is shaping up to be known as the courtroom trial election, as Trump could be spending a lot of time at the defendant's table in Washington, D.C., Florida, and Georgia at the same time that voters are going to the polls. To discuss the facts of the cases, I'm Amy Sherman with PolitiFact, and today I'm joined by Palm Beach County State Attorney Dave Aronberg and John Sale, a white-collar criminal defense attorney in Miami. John is a former Watergate special prosecutor, a former attorney for Rudy Giuliani, and he also declined a request to represent Donald Trump. So I wanted to start first with what we saw yesterday with Trump testifying on his own behalf in the civil fraud trial in New York. Dave, why don't you go first? Any thoughts about his testimony, and does it shed any light on what we can expect about how Trump will handle being a defendant in court in the criminal cases?
Amy, good to be with you and my friend John Sale. I don't think this will be a harbinger for how he's going to testify in the criminal cases, because first, he's not going to testify in the criminal cases. He could be walking into a perjury trap, and he's under no requirement to testify. But in the civil case, if he took the Fifth Amendment, it would be used as an adverse inference against him. So he testified, and he was testifying for his MAGA base because he was defiant, and he just spewed lots of stuff against the judge and against the attorney general's office, and had to be admonished multiple times by the judge. You're not going to see that in a criminal case. But he did this for a reason. He did this, number one, to play to his strident base, because nothing motivates MAGA more than martyrdom and grievance. And number two, I think his only chance at prevailing in this case would be on appeal, because after all, he's already lost this case on summary judgment. Now it's really just a question of damages. But he is hoping that if he could goad the Judge Engoron here, to making a mistake, to show bias against him, he could possibly get an adverse ruling overturned on appeal. So that's why he did what he did with all the histrionics. It was not to win now, but perhaps to win later, and to try to win within his base in the court of public opinion.
John, can you talk about, as a defense attorney, was it helpful for Trump to take the stand, and why do you think his lawyers allowed it?
Allowed, it maybe is the word that I can address. I mean, you can make a recommendation to a client, but whether or not to testify is a decision that the client makes. So I don't know what he was advised, but I agree with Dave. He makes a very good point that one of the things he might have been trying to do is goad the judge into just losing it and saying something that would show bias, because there are certain norms that we lawyers live by. There are certain just standard practices for everybody. I mean, I prepare clients to testify frequently. You don't go after the fact finder. You don't go after the judge. You don't sit there and go off and make a political speech. I mean, the judge said to him, if you don't answer the questions, I'm going to draw an adverse inference from your testifying. So I think in the courtroom, he lost. He made certain admissions, which I think can be used against him even in this damage phase. But in the political arena, to his audience, this was a big victory for him. And I'll bet you when you look at the fundraising statistics when they come out, I think you're going to see that this performance of his was a Grand Slam home run.
Dave, broadly speaking about all these cases, what would you say to liberal voters who are salivating at the idea of Trump in a jail jumpsuit, and to Trump fans who are confident that all these cases are much ado about nothing?
Well, I think both sides need to lower their expectations a little bit. First, as far as liberal voters who think Trump's going to wear an orange jumpsuit, I mean, there is a possibility. But I think the only criminal case that will be decided before the election will be the Washington, D.C. election interference case. That case was built for speed. Jack Smith only charged 4 counts. It's scheduled to go in March, and you've got a judge and Judge Chutkan who ain't messing around. That's going to go first. There'll be a verdict before the election. And I have a disagreement with some of my friends. Glenn Kirshner, who's a political commentator, insists that Judge Chutkan will send him right to prison. I'm not so sure. I think that the judge may allow him to appeal and hold off on sentencing. So in that case, I don't think he'll be running for president from a prison cell. But if he doesn't win, yeah, then I think you could actually see him wearing a pair of steel bracelets and an orange jumpsuit. Now, as far as and the other cases, I don't think the other cases, with the exception possibly of the New York State case, the Stormy Daniels hush money case, I don't think the other cases will be heard before the election. And the New York case may not result in any jail time. That is the least strong of the 4 cases. Now, as far as the Republicans who say this is much ado about nothing, get real. I mean, this is real stuff. I mean, this involves stealing nuclear secrets. This involves trying to overturn an election. RICO is always to be taken seriously. So this is serious stuff. It's just that the strongest case here, the case down here in South Florida in front of Judge Cannon, the Mar-a-Lago documents case, I think almost certainly will happen after the election. So Trump could get out of all of this by winning the White House, shutting down the cases that are pending, trying to pardon himself or get his vice president to pardon himself for any conviction he has. And for the state cases, he'll surround himself with Secret Service and dare the Fulton County and New York DAs to come and get him.
John, anything to add to that?
Well, talking about the Democrat voters and the Republican voters, when the first indictment was returned, that was the New York case, Jim Comey, the former director of the FBI, tweeted, "It's a great day for America," or something like that. And I couldn't tell you how much I disagree with that. I think that the fact that the former president of the United States is indicted once, much less 4 times, is not a great day for America. I think it's a very sad and solemn day for America. And I don't think we should take any joy in this. I don't think the criminal justice system should be used to determine who's going to be president or not. I think if a prosecutor brings a case in good faith, Mr. Trump, like everyone else, is entitled to a fair trial where he's presumed innocent, and he should be convicted or acquitted based upon getting a fair trial from a fair, unbiased jury. I think that that's the very Constitution that he said should be suspended, should protect him. And I think that there's a big challenge that Judge Chutkan has in Washington, D.C. case, and that's to, first of all, pick a fair jury. I mean, that is extraordinarily difficult in this case. And you have to be careful about what they call phantom jurors. You can have people who just want to get on the jury, who are going to hide their bias. And Judge Chutkan's another challenge is to keep him to behave, for lack of a better word. There are all sorts of things that he might do. After all, just think about it. He's the former commander-in-chief, the former most powerful person in the world, who is going to be in a courtroom with one African-American woman wearing a black robe, who is going to be telling him he's got to behave like any other defendant, which he should, who's going to come before him. I don't know he's going to react, no matter what these lawyers tell him, very well to that. And before you even get to whether or not he testifies, I mean, he could just not behave himself at counsel table. And if it was any other defendant, a judge, the action would be, you'd warn him a couple of times. And if he keeps doing it, take him out, put him in a jail cell. You can't do that with Donald Trump because he was a former president. So there is no rule book, because we've never had a former president indicted and going to trial. I think the Washington, D.C. case, the only thing that could prevent a trial would be if the matters are stayed on appeal. And there are a couple of matters which could be appealed, what we call interlocutory, before the trial. And there's no guarantee how long the Court of Appeals would take and whether or not the Supreme Court would take it.
Okay. An appeals court recently paused the gag order in Trump's 2020 election case. Trump has said that gag order amounts to the Biden administration taking away his right to free speech. John, can you talk about if this gag order is constitutional and is it unique?
Well, it's not the Biden administration. I mean, his team keeps saying it's the Biden administration. It's the United States, it's special counsel who is independent of the White House. But I think that as a candidate, serious candidate running for president, he has the highest degree of protection under the First Amendment for free political speech. And the reason there's very little authority on this is that usually gag orders are not common, but I've seen a lot of gag orders, but they usually gag the lawyers. They don't gag the client because I've never had a client who, and it's not that I'm the bellwether of anything, but clients usually, on the lawyer's advice, keep their mouth shut. And it's usually the lawyers who hold the press conferences that have to be reined in. So there is one case, and I think the Sixth Circuit, involving Congressman Harold Ford Sr., which overthrew a gag order. And I think that this gag order, as much as Judge Chutkan tried, I think it's too broad. I think, for example, he has to be allowed to answer and criticize some government witnesses who write a book, who go on television and criticize him. Like, I think Bill Barr, the former Attorney General, had a lot of courage to say, no, there's not widespread election fraud. But when he goes on television and talks about Trump's defective personality and what a threat he is, I think, he's a witness, but I think Trump as a candidate has to be able to answer him. So I think a gag order has to be restricted to what the Ford case said, if it's a clear and present danger, if it's going to promote violence. And I think that has to be reined in, but I don't think it can be any broader than that.
Dave, any thoughts on whether the gag order is too broad and about Trump's comments suggesting that it's not constitutional?
Well, I'd like to agree with John. He makes some good points that you have to allow Trump to be able to respond to Bill Barr from a political context. But when you go after Mark Meadows, for example, which is why the gag order in D.C. was reinstated by Judge Chutkan, and now it's stayed again pending appeal, as the D.C. Circuit is going to review it. But the reason why you should not want him to go after witnesses is because it affects his case directly. You don't want him to threaten Mark Meadows, saying that, of course, he's smart enough not to speak, and this subtle mobster type of language that is meant to intimidate witnesses. That cannot be allowed. So that's the only thing I would add to what John said, because I think John is right that perhaps we can tweak the gag orders somewhat, but when it comes down to intimidating witnesses, there really should be no tolerance for it.
Well, one of the problems is you can't fashion a gag order by individual witnesses. You can't say, well, you can talk about Barr, but you can't talk about Meadows. So it's a very, very difficult thing to craft a gag order. We have to bear in mind, in this country, the First Amendment allows all sorts of speech that Dave and I would find abhorrent. And the gag order, I don't know that it's an answer, because even if Donald Trump abides by it, his surrogates will do the same thing. So, and it's if there is intimidation, if people are to be intimidated, his surrogates will intimidate them. And there's no way that Trump could be held responsible for that unless you have an evidentiary hearing and there's proof that Donald Trump put them up to that. And that proof that would probably never be established. So, and I know it's better to have an answer than just to say there's a question, but I think it's a problem. I don't know the answer, frankly, as to we don't want witnesses intimidated, but how does that balance with the First Amendment? And that's what the courts have to struggle with.
Any thoughts on, if he violates the gag order, what consequences we have seen or we will see? Is this idea of these fines and the dollar amounts that we've seen so far, does it mean anything to him?
If I could jump in on that one. Look, Trump and his supporters have said that there's a two-tiered justice system, and I'm inclined to agree with that. I agree, but not in the way that Trump and his supporters are saying. I think that Trump is being treated better than most defendants. I have never seen a defendant be able to lash out the way he has at the judge, at prosecutors, at witnesses, and not get sanctioned heavily. I mean, like, in most cases, that defendant would be in jail right now pre-trial, but at the very least, they'd be sanctioned in a significant way. The only sanctions against them thus far in any of the cases is from Judge Engoron in his civil case, who has sanctioned him by fining him once $5,000, the second time $10,000. For a self-professed billionaire, that's not a lot of money. That's a slap on the wrist. Plus, Judge Engoron's order only applied to Judge Engoron's staff, his clerk, and others who work for him. It did not apply to the judge or prosecutors. he just extended it to include not just Trump, but Trump's lawyers. But still, in any other case, those gag orders would be much broader than they are and have much more severe consequences.
Hey, we all agree that no one, including Donald Trump, is above the law. And everybody says that. That's nice rhetoric. But what I've said from the beginning is, while he's not above the law, let's be honest about it, not hypocritical. He is treated differently because he was former president. I could give you instance after instance. In the Southern District of Florida case, where I have most of my practice, any other defendant would have been put in the lockup, would have been put in handcuffs. Here, they didn't even take a mugshot. The standard condition of release for every defendant, unless a judge changes it, is you can't leave the Southern District of Florida without even a request from the Trump camp. That was extended. He is treated differently. And whether you call it above the law or below the law, I think the truth of the matter is he's treated differently. And I think we're talking about if he violates the gag order, the real question is, so what can a judge do about it? And if we're any other defendant, they would gradually impose sanctions and then they'd lock the person up, and without any hesitancy. The FTX, Bankenfield, how do you pronounce his name? Sam Blankenfield. Bankman-Fried. His bond was revoked for social media posting, which was interpreted to threaten witnesses, and he went through his trial in jail. But as Dave said, of course, anyone else would be put in jail. I don't see Judge Chutkan or any other judge putting him in jail pre-trial.
I agree. I agree with that.
Which means he can be above the law. He can get away with something that no one else can. And that's unfortunate, to say the least, but I think that's the reality.
Okay, for our listeners who maybe are just joining us now, I'm Amy Sherman with PolitiFact, and we are here discussing the Trump trials with Palm Beach County State Attorney Dave Aronberg and John Sale, a white-collar criminal defense attorney in Miami. John, can you talk about Trump's often repeated defense? I think he made it in the civil trial and many criminal trials, is that these are political prosecutions and election interference. As a lawyer, what do you make of that argument by him?
Well, I think a lot of it is just political rhetoric, which he's absolutely free to say on the campaign trail. And I think under Judge Chutkan's order, which has been stayed, he's allowed to say things like that. But when you get into the courtroom where it really matters, they have a motion based upon prosecutorial misconduct. And they want to allege that once President Biden heard that his son was being investigated, he directed that the Justice Department prosecute Trump. Well, it's easy for him to say that on the campaign trail, but they actually have to have an evidentiary hearing and real proof of that, which they're not going to have. So in the courtroom, none of this is going to be allowed. I mean, this case the Washington, D.C. case, hopefully will rise or fall on the evidence or lack of evidence. As I said before, I'm repeating just for emphasis, it's so important because the whole world is watching that if it is brought to trial, that he get a fair trial.
Dave, any thoughts on that? Do you think that Trump's argument that this is election interference is appealing to some voters?
It's appealing to his base and to voters who aren't paying attention. But for those who think this is the weaponized Department of Justice, Hunter Biden would like to have a word. I mean, you have the Attorney General who has allowed a special prosecutor, a holdover from the Trump administration, to investigate and prosecute the sitting president's son. Try that under Bill Barr and Donald Trump. Bill Barr would have a one-way ticket to Guantanamo if he ever tried to do that to Trump's children. Also, Merrick Garland here, the Attorney General, has shown that he is apolitical, not just in prosecuting Hunter Biden, but look, he's the one who decided not to prosecute Matt Gaetz, one of Trump's biggest supporters. It was the previous Attorney General, Bill Barr, who opened the investigation of Matt Gaetz. Merrick Garland said not enough evidence, closed it. It was the Department of Justice that took Donald Trump's side against E. Jean Carroll in the civil lawsuit on sexual assault. So when they say, well, this is politicized, they're projecting from the last administration. But the reality in this administration shows that Merrick Garland bends over backwards to try to prove that politics has nothing to do with it.
Hey, the Southern District of New York U.S. Attorney's Office under Merrick Garland declined to prosecute the Stormy Daniels case.
Good point.
Dave, as a prosecutor, can you talk about the timing? I've seen some Trump allies say, well, we think this is election interference because they timed the charges and the trials with the election year, when particularly in the 2020 election case, they had a lot of the evidence in late 2020, 2021 about his role. Can you talk about why it took as long as it did to bring about the indictments and the trials?
I do think because Merrick Garland tries so hard to be apolitical that he was slow rolling this investigation. I think the fact that they had to bring in a special prosecutor to show that they were being even-handed and apolitical is another reason why there was a delay. And eventually Jack Smith came in and lit some fires, and now you have what you've seen. But I think it is legitimate to criticize the slow process at the beginning, but there were a lot of newspaper articles that did some research into it and showed that some of the holdovers from the Trump administration were not quick to move forward in this investigation after January 6th. And so it was a slow process. And look, it was Donald Trump who decided to announce for president extra early, earlier than any other candidate, because he wanted to intimidate Merrick Garland, because he wanted to make this argument that he was being persecuted because he was running for president. So he tried to work the calendar to try to make it look more beneficial to him that he was being persecuted. Merrick Garland, you can criticize him for being slow because he can be a little too careful. But to say that this is a political persecution, a mess with the election, would just mean you're saying that certain individuals are above the law.
Well, there is a Department of Justice policy about filing charges within 60 or 90 days of an election. And if you read the Justice Manual, which is like the Bible for prosecutors, federal prosecutors, it talks about that no charges should be brought which might interfere or be perceived to interfere with affecting an election. Well, that it is, if you read it literally, it's charges filed. But you could make the argument that trials also shouldn't be held at a time when it could be perceived that they're being brought to interfere with an election. So I agree with Dave that Merrick Garland is totally non-political, and that's not his intention. But I think we get into dangerous territory when we require the likely nominee of the opposition party to sit in a courtroom the day before Super Tuesday, which is when the trial is set for now. I think that the public might lose some confidence in the system.
Dave, can you talk about how much time realistically we could see Trump in trial in 2024? And then as a politician, what is that going to mean for his ability to campaign?
Now, the 4 criminal trials are set before the election, or at least 3 out of the 4. The Fulton County one, there's no trial date for that. But I think the only one of the 4 that will happen before the election for sure is the Washington, D.C. one, unless, as John said, there's some appeals that could slow it down. But I think almost certainly, in my mind, that's going. The New York case and Stormy Daniels could go. The D.C. case, which will go first in March, is scheduled to take between 6 to 8 weeks. So that case will be concluded. Now, how would that affect Trump's campaign? Oh, it affects it a lot because he'd have to be in trial. Unlike civil cases where your appearance is voluntary, he's going to have to be there. And you've seen lately, this is clear weighing on his mind. I think some of his gaffes that he's made in recent weeks are because of the stress of all these cases. I mean, saying that we're headed towards World War II, or that he ran against George W. Bush, and that Barack Obama is president. And just the other day, he said that he won 50 states in the election. I think some of the crazy rhetoric that keeps getting worse and worse, I think is partly because of the stress of these trials. And when he's facing potential incarceration, when it gets real to him, I think it's only going to get worse.
Well, Governor Christie, who granted he's former President Trump's opponent, who knows him very well, has said publicly that Donald Trump is afraid of going to prison. And I've had a lot of clients, not talking about former presidents, but people who are of all different egos and high positions under investigation, every one of them is afraid of going to prison. It's only human. And I'm agreeing with Dave. As this gets closer and the reality sinks in, there's going to be come to reckoning. But there's a Rule 43 of the Federal Rules of Criminal Procedure says that he has to be present. He has to be present at the trial. But it give a little bit of wiggle room. And there have been exceptions, for example, for illness. A trial is continued on, and a defendant has said, I know I have a right to be there, but let the trial go on without me. And I think this is an extraordinary circumstance where he might not want to sit there every single day. Now, I've never had a client who hasn't been present every single day, but I've never had a client who went to trial who was running for president of the United States. And there are exceptions in extraordinary circumstances. So, I don't know how that would look with the jury. I haven't thought it through. But, him sitting there in a criminal trial for 8 weeks would interfere with his campaign. I don't think there's any question.
Okay. Just a note for our audience, feel free to put your questions in the YouTube chat. And we decided to make United Facts of America free this year for all our guests, but you can still support the truth in politics. Visit politifact.com/donate to make a difference to our efforts to fact check Democrats and Republicans. John, as a defense attorney, can you talk about what a defense attorney would look for jury selection? This is a defendant. The jury pool is going to know him. They're probably going to know at least something about the allegations. How do you figure out who to pick?
I don't want this to sound wrong, but if I would not want smart people. Smart people would pay attention to the facts and the law, which they should do. But people who are just feel unhappy and want to blame somebody for crime or for the open borders, or who want to blame people, I think that they may think that Donald Trump is their savior. So I think it's sort of like reversed in the typical kind of a case, that as a defense lawyer, I would want to strike doctors and lawyers and educated people and people from the so-called establishment. I would not want any of those people. I would want people who feel angry. That's what I would want as a defense lawyer.
Would you be asking them their party affiliation and if they had voted for Trump in the past, or if they plan to vote for him in the future?
I don't think that's a permissible question. I don't think the judge would permit that. There is a questionnaire. The special counsel's already made a motion to allow a questionnaire to go out to lots of prospective jurors to try and find out a lot about them. But I don't think Dave, you may know more than I do about this. I don't think you're permitted to ask somebody who they voted for last time, who they're going to vote for. I think that's a right of citizenship to keep confidential.
You can still get that information out of them in other ways. But you may not be able to ask how they voted, but you can find out,
Right. You can also check party affiliation by public records.
One thing about this is that just because you'll get a Trump supporter on a jury doesn't mean they're just going to be a MAGA blind follower. And even if they are, if you just get 1 out of 12, that's usually not enough. Usually there's safety in numbers, and you have to have a couple to really put a wrench in the gears. There was a guy who listened to right-wing radio in the trial on the E. Jean Carroll case of Trump. He listens to some of the most conservative podcasts, and he went along with the unanimous verdict against Trump in favor of E. Jean Carroll. There was a guy on the Paul Manafort jury who was a Trump supporter, and he voted to convict Manafort because he said, I just follow the evidence. So you just have to vet these people to make sure they're going to follow the evidence and the law.
Okay. In the documents case, your average juror is probably not familiar with any of the laws that pertain to handling of classified documents. Also, President Biden's handling of his documents is under a separate investigation. Dave, would either of those factors pose a challenge to the prosecution of Trump?
I don't think so, Amy. I think this is the strongest case. They got him dead to rights. Trump has no defense here. It's not about intent. It's just whether he possessed the documents after he was told to give them back. And the answer is, of course, he did. His only possible defense is that, well, he declassified the documents or thought he had declassified the documents. But that was disproven by the recording from Bedminster. We admitted he did not declassify the documents and that he can't show them to people while they are classified. So they got him on the willful retention of documents. Now, to those who want to compare this to Joe Biden and Mike Pence, who was cleared, this is not about the possession of documents, but the refusal to give them back. It's the refusal to give them back. It's the obstruction, stupid, as the line from the Clinton campaign would say. And that's why he really has no defense. And if he had just given them back after he was asked, there would be no case against him in Fort Pierce.
Well, the declassification doesn't really matter under the.
True.
It's just possessing under the Espionage Act, just possessing these documents, as Dave was saying. But if he had complied with the subpoena in the Fort Pierce, which was then a West Palm Beach case, there would not have been a charge. It was, rather than comply with the subpoena, if he wanted to assert certain privileges, he had a right to do that in court. But instead, he instructed his lawyers basically to deep six, allegedly, these documents. And the obstruction part is the strongest case. A judge in Washington, D.C. found this crime fraud exception, and the principal witness, although a reluctant witness against him, is his own former lawyer who's going to testify that he instructed us not to comply with the subpoena. So the obstruction part, I agree, is compelling.
I mean, if I could add, John's right about the fact that you don't even need to declassify the documents or have a classification debate. It's not subject to the statute. The statute, it covers classified and declassified documents, but prosecutors would not have brought this case, I believe, if Trump had declassified the documents, because all you need is to convince one juror that there was some issue on declassification, even though it's not the law. But they're not going to walk into a minefield, these the prosecutors. They want these airtight cases, and they've got it in the Mar-a-Lago documents case.
And for our listeners, I think we've written a story about this. If you Google PolitiFact, Trump, and in-brain classification, we asked some legal experts if such a thing exists. So you can read that story there. John, Trump might invoke the advice of counsel defense in the federal 2020 election case. Can you explain what that means in layman's terms?
If you make full disclosure to your attorney, and your attorney gives you advice that what you're doing doesn't have to be legal or not legal, it's criminal intent. What you're doing is okay, is kosher, and you've made full disclosure, you're waiving attorney-client privilege by doing that. The advice has to be reasonable. It can't be saying, oh, okay, you've told me everything, so go rob a bank. So, and it's a difficult defense, but it's not uncommon. But I think there's another interesting argument that I think Trump can make, and that's the government cannot pick and choose which lawyers you can listen to and which you can't listen to. And that there are a whole bunch of lawyers, and you, government, have made some of them unavailable to me by charging them. And by charging them with crimes in their own self-interest, they're going to take the fifth. And let me just say quickly that I think the guilty pleas that were done in the Fulton County case are outrageously lenient. Just to give you one quick example, and I could say the same thing about all of them. Ken Chesbrough, who was charged in that indictment with being the architect of the phony elector scheme. That's one of the most serious crimes I can think of. That goes to the very heart of our democracy, of our republic. His plea is probation. It can be expunged after a year, and he has to write a letter of apology, of course, and they've stipulated that it's not a crime of moral turpitude, which means the prosecutor is helping him even keep his bar license. Well, his lawyer said, how could we turn that down? When you give pleas like that, of course they're going to enter plea. And I tell you, in the federal case, where someone like Chesbrough and the rest don't have any protection, that's going to be confusing. They are not going to get pleas like that. And those people, he's one of the unindicted co-conspirators, they're going to face serious charges, and it's going to confuse everything. When Jenna Ellis, in her allocution, that means when she was talking, she said, if I knew then what I know now, well, it doesn't matter what you know now. What should matter is what you knew then. You had to have the criminal intent then. And then she says, and I follow the more experienced lawyers. So she's not taking responsibility for anything. So I think that those guilty pleas go to the question the integrity of that whole RICO case in Atlanta and make Jack Smith's life a little bit more complicated with how those people are going to be handled in Washington, D.C.
One thing I've wondered, I don't know if either one of you can answer this, is in these sorts of white collar cases, when there is a plea and the defendants are sentenced to community service, do they tend to buy their way out of it, or do they actually do the community service? I don't know if either of you can talk about what you've seen in any cases.
I can tell you in my jurisdiction, they do it. Now, sometimes they can get like a friendly charity who will sign a letter saying, yeah, he's worked the 90 hours or whatever it is. But as far as buying their way out of it, they can't just pay. There's a fine component that's separate to the community service, but you just can't pay your way to get out of the community service. But there are ways to convince a friendly charity. If you give a nice contribution, I would think perhaps to write that letter, but it's not supposed to happen.
Okay. John, if Trump wins, legal experts have debated whether he can pardon himself. Any thoughts about that?
Well, constitutional scholars differ on that. So, and obviously there's no authority for it. There's never been a president who pardoned himself. Although Dave had something interesting to say before, he could not pardon himself on state convictions, but as a practical matter, if he's president of the United States, he's not going to be arrested by some local sheriffs. They're not going to come to the White House and say, excuse me, we're here for the president. Please turn around. We're going to handcuff you. You're going to prison. So that's another kind of a pardon. It's a practical pardon. The whole ballgame here is the election. And that's why maybe he's quite wise in his strategy, that the way he testified yesterday. The more he can get public support, the more chance he has of winning. And I'm not a political analyst. I don't know if he's going to win or lose. But if he wins, he's not going to have to worry about any of these criminal cases. But as Dave said, it's the Washington, D.C. case in which our criminal justice system is going to be also on trial. So is the rule of law. And I just think that everything there has to be done right.
Dave, anything you'd want to add to whether Trump can pardon himself, or whether we might see whoever wins the presidential election, if it's not Trump, ultimately deciding to pardon him?
Well, Trump will order his attorney general to drop all the pending federal cases against him. And I agree with John Sale. I think that if he is president, the state cases will at least be put on hold and may never happen after he leaves the office. So 2024 is for all the marbles. I mean, this is for our democracy, or the rule of law. If on the question of whether he can pardon himself, I think you cannot. It has not been decided by any court. We've never been down this road before. But if you look at the wording of the Constitution, it says that the president has the power to grant pardons. And generally the word grant means give something to someone else, not to yourself. But he could invoke the 25th Amendment, where he hands power over to the vice president for a small period of time. Vice president pardons Trump, and then Trump then writes a letter to Congress reclaiming power, and lickety split, he is pardoned. Now, anyone who does that as vice president will be unable to run for any major office again. It was just like Gerald Ford couldn't get elected after pardoning Nixon. It would look like a dirty bargain, and that vice president would end his or her political career, at least in the chance of running for president, but would still be a MAGA hero and be able to raise a lot of money on the circuit afterwards.
All right, we have a question from the audience, and I think this could go to any of the criminal cases. Are there any facts to which a defense attorney would not want attention drawn to during the trial?
Well, I think in the federal cases, I think the prosecutor's office has been so thorough that as a defense lawyer, you don't want any of the facts to come out. I think you'd want to confuse the jury. And I don't think that that's disingenuous, because in our system, it's up to the prosecution to prove beyond a reasonable doubt the guilt. And the facts in these cases are, if I were representing the president, would be my worst enemy. So I would not want any of them to come out.
And Amy, it shows that why the Fort Pierce case, Mar-a-Lago documents case, is the strongest case. Because as we discussed earlier, and John brought this up, Trump could use the advice of counsel defense, perhaps in the federal case. His attorneys, by the way, have not been charged in that case. They have been charged in the state case in Georgia and have pled guilty there. There's also the First Amendment defense. And then all it takes is one juror to have some reasonable doubt. It's a hung jury. So he has a shot in those cases. The New York case on Stormy Daniels, hush money payments, the law is a little weak in that area. It's a bunch of misdemeanors. They've got to show that his falsification of business records led to another crime, but it's not clear what that other crime is because the DA hasn't said it yet. So we'll see how that goes. But in South Florida, in Fort Pierce, there is no defense in that case. He previously tried to say the FBI planted evidence, not even going to be allowed to say that in court. The declassification defense is not a defense, as we mentioned earlier. So that's the case that Trump does not want to go to trial. Fortunately for him, he's got a judge who has been very amenable to him, giving delays and rulings that are favorable to him, and Judge Cannon. And so the strongest case against him is the least likely case to be tried before the election. Another reason why the November 2024 election is the most important election in history.
A Georgia State University law professor described the hush money Manhattan case as probably the weakest in terms of legal theory, and I think it's come under considerable criticism by even liberal legal experts, the professor said. John, do you agree with that?
Totally. I think that case is a mistake. The feds looked at it carefully and passed on it. And I think I've never seen a case, and I had a relative high position as a prosecutor, and I have an active criminal defense practice. I've never seen a case where the main government witness goes on before he testifies, goes on every television show, writes a book. I forgot the name of it. I'm talking about Michael Cohen, called what was it called? Revenge or something like that. And I've never seen anything like that. So I think he is very impeachable. If you look at the government, in the case where Michael Cohen pled guilty and went to jail in the Southern District of New York, and he says that, look, I went to jail for Donald Trump, so in fairness, he needs to be punished. If you look at that case, you'll see that the prison sentence he got, this is based on the judge and the government's position, was based only in very small part on the hush money payments. It was based upon all of Michael Cohen's other crimes, financial crimes, and taxi medallions. So I think he's one of the most impeachable witnesses I've ever seen. I think a case that's borderline misdemeanor, felony, maybe a misdemeanor, is not the case to be brought against the former president of the United States. I just think that case is a mistake. I think the federal case, as Dave said, both of them are serious threats to Donald Trump.
And as far as Michael Cohen's book, it was named Revenge, and the one before it is named Disloyal. Good for defense lawyers.
We're almost out of time here, so I'll ask Dave first. Any final thoughts on anything we didn't cover about the facts related to these Trump trials?
You know, the Fulton County case is interesting. You've got 19 defendants now. It's whittled down after a bunch of people pled to very lenient charges. John's right. But that case is RICO, which is serious. That could put him in state prison for some time. Those cases, though, take 6 months, and that's why I don't think it's happened before the election. And after the election, if he is not president again, I think he goes on trial. But if he becomes president again, I think we're in a constitutional crisis, and who knows what happens there. The one thing that Fulton County case has that the other cases do not is a recording of Donald Trump in his own words saying, find me 11,780 votes. That's going to be powerful evidence in front of a local jury, a jury of where they went for Biden by 72% of the vote in Fulton County. So don't sleep on that case. That case is a serious case, and it's moving ahead. And so it's important for the public to know how important this election is, not just on issues and the fate of our democracy and foreign policy, but also on the rule of law. It's very, very likely that if he is elected to the White House, these cases go away for the sole reason that he's president. And so you would have a situation where someone is above the law.
John, any final thoughts here?
Well, Dave's reference to the recorded conversation in Georgia, find me 12,000 some odd votes, that's subject to interpretation as to what's meant by it. But what I agree totally with Dave is I'm not worried about any particular case. I am genuinely worried about the rule of law. And I think that potentially Mr. Trump poses a threat to the rule of law. And however the cases come out, I'm just worried for our republic. And I just hope that every officer of the court stands up and says the rule of law should prevail, however, and let the chips fall where they may.
Okay, we're going to have to leave it there. Thank you to Dave and John for your invaluable insights and dedication to truth. United Facts of America continues at 11 a.m. tomorrow with a discussion about artificial intelligence's misinformation threat amid the Israel-Hamas war. And then tomorrow night at 7 p.m., we're going to take you behind the scenes about how we prep for Republican presidential debate. And that will be 1 hour before the debate begins in Miami. Until then, I'm Amy Sherman. Take care.